law mean over there?
My short answer to that.
I think counsel.
Sir, I'll just complete
no,
my
I
submission.
think counsel is entitled to argue any which way they want to.
Achha.
Let us hear you.
Yes.
I have to hear you decide what you say, and if we have already formed opinions, we can reflect them in our judgments. Please continue. Otherwise, we will never conclude these hearings.
An opinion. This is a question that, as a judge of the court sitting on this bench, I am entitled to ask.
Of course,
counsel.
ask it. Let the
So I'm
counsel
asking
finish
the
his submissions.
If I'm interrupted all the time, I'm sorry to say, sir, that is not proper.
I think the interruption
asking-
is of
I'm
learned
asking-
counsel.
I'm
Chale
asking
learned counsel, aap aage बढ़ें.
I am asking counsel a question, which is my right to ask the counsel. If he wants to answer
After
it,
he
doesn't
concludes
answer
his
it,
submissions with
if
the
he
greatest
wants
of
to or
respect.
doesn't want to, that's his issue. That's not my issue. You understood the question now?
My lord, I'll address that question. Let me just finish this submissions on competence and then I'll address this question. My lord, so I think there can be no doubt about what the word law means in Article 191 in the context type. But if your lordship requires a constitutional context, then subject to law also occurs in the Constitution, and it has been interpreted by your lordships of what that means, and that has been interpreted as meaning an act of Parliament. A recent judgment on this is a judgment authored by Justice Mansoor Ali Shah Sahab in the extension case, which is PLD 2020 Supreme Court, page 1, and your lordships are aware, if your lordships look at 243, sub-article 3, which contained the same language, although subject to law was not in the beginning but in the middle. The President, subject to law. And his lordship, Justice Mansoor Ali Shah, in para 27 of that judgment, said this means an act of Parliament. So there, another judgment, my lord, on this would be the Baskakar case. Now, if your lordship, as your lordships are aware.
Baskakar.
Ji.
Baskakar. Okay.
Whether law has been defined in the Constitution?
No. Existing law has been defined.
Kindly see 260.
Federal law is also.
Federal law has been defined.
Ji, law has not been defined. Existing
Federal law
law.
has been
Ji, federal law has
Siddiqui
been
sir, please continue your arguments.
When 191 says of a law, does it talk of existing law or does it include a law that subsequently may be legislated?
It cannot talk about existing law because existing law is a defined term in the Constitution under Article 260. And that is a reference to Article 268, sub-article 7. So when existing law is used, it's a defined term in the Constitution.
So where it is defined, then the Constitution must have used the term existing law somewhere.
Yes, in
Where is that?
268.
No, वो तो defined हुई है ना.
It is in 260.
Other than the
260, yeah.
definition, where in what articles, what other articles has this term been used?
It is being used in 268. It has been defined and used in that, as far as I am aware. But it is a defined term. So if they wanted to use existing law, your law would have been used.
Mr. Siddiqui, it seems that, albeit the fight is about me as being as a master of whatever, you're not hearing what I'm saying at all, and you're completely ignoring.
Sir, I'm not,
I mean, you don't want to make your submissions.
Sir, but
you should just sit down and answer questions.
I'll complete my submission.
So why aren't you making your submissions?
No, my lord, leaving aside the issue.
Mr. Faisal Siddiqui, just 1 minute. You've given the example of Article 243. The President shall, subject to law, have the power to do what? Raise and maintain military, naval and air forces of Pakistan and so on. But the difference between law over here is, and this is the point that yesterday was made with other learned counsel, that this relates to a specific entry of the Federal Legislative List, i.e. entry number 1. Law over here is relatable to entry number 1, a specific entry
I'll come
of
to
the
that.
Federal Legislative List. And this was in relation to Article 202.
No, I'm simply saying that the word term subject to law as used elsewhere has been judicially defined in a certain, whether Article 191.
There's a context. What I'm asking you is,
Yes.
there is a context to Article 243, and the context that appears to be missing in relation to Article 191, where there is no specific entry, for example, in relation to the Supreme Court. So which particular legislative list would you link the use of the word
That
law?
is where I'm coming to, my lord. When it comes to practice and procedure, I will be relying on entry 58. When it comes to the appellate jurisdiction under section 5, I'll be relying on entry 55. So I'll come to now this submission. I just wanted to clear as far as this word law is concerned. Now, let me come to my first part. As your lordships are aware, there are two parts to this law. One relates to practice and procedure, and then there is section 5 which relates to appeal. Although there is a judgment by His Lordship Justice Muneeb where he has said as far as legislative competence is concerned, even appeals are a part of procedural law. I'll be referring to that judgment. So, if appeals are also a part of procedural law as far as legislative competence is concerned, then they would even be covered in practice and procedure law. So let me first come to how practice and procedure is covered. My lord, if your lordship may kindly see my note, I rely on entry 58 read with article 191, my lord. Now, my lord, it is, if your lordships accept my argument, which is that subject to law also includes acts of parliament, if I can safely make that presumption, then in order not to make this word redundant, there must be some power with someone to make this law in the Constitution. Otherwise, the word will become redundant, my lord. Now, that power, my lord, cannot be based on entry 55. It has to be based on entry 58. The reason I say that is entry 55 deals with, as apart from practice and procedure, it deals with jurisdiction and powers. When one is talking about practice and procedure, one is not talking about jurisdiction and power. I make that distinction. Now, a question was raised as to entry 58. If I may draw your lordship's attention to entry 58. It's quite a complicated entries, both of them, my lord. If your fourth schedule, sir, entry 58. Now, a question arose as to a very important term which is used in both the entries. It is by or under the Constitution. Entry 55 uses the word by or under the Constitution. Entry 58 only uses the word under the Constitution. If I may read, matters which under the Constitution are within the legislative competence of Majlis-e-Shura or relate to the Federation. What does this term under the Constitution mean as opposed to the word used in entry 55 by or under? My lord, this is a term which is used in the Constitution also, by and under the Constitution. It's used once in Article 69. It's used under the Constitution is also used in other parts of the Constitution. Now, I think the answer is something which Justice Ijaz had given, is that under the Constitution means the necessary implications. So that is how at least the Indian Supreme Court has understood this. What necessarily follows from a certain article. It's like something which can be prima facie implied from an article. Now, my submission as far as Article 191 is concerned, my lord, is that it is not something which is very different from the rest of the entries, as Justice Muneeb had observed yesterday. I think it's a substantive entry. And that is how it's been understood by the Supreme Court in the sui gas case. There's a whole para on entry 58 and 59 that these are independent and substantive entries in the Constitution which independently and substantively confer competence. Now, my submission before your lordship is very simple, which is that if law in Article 199 means Act of Parliament, and if we are not to read law as in 191 as redundant, then there has to be legislative competence which has to be found somewhere for practice and procedure. Now, that place where it is found can either be entry 55 or entry 58. It cannot be entry 55 because we are not talking about jurisdiction and powers. It has to be entry 58. And entry 58 contains the keywords, which is not by the Constitution but under the Constitution, as necessarily being implied. The necessary implication of an article is that it confers judicial power. So that is why one part of subject to law.
Entry 58 with what? With which article of the
191, and I also.
191, you see, as the language, as the simple reading of 191 says, it is a power conferring article, and that power is conferred on the Supreme Court. So ultimately, the rules which have to be framed under Article 191 is a power of the Supreme Court, not of the Parliament.
My Lord, there are two conferring powers.
In framing the rules, the Supreme Court is supposed to follow the Constitution, and I would tell you, speaking for myself, any existing law or any law that was prevalent or was in force at that time. Entry 191 does not, Article 191 does not confer legislative power on the Parliament to frame rules for the Supreme Court.
My Lord, then the words under the Constitution would have to be given another meaning, because there is express conferment, as your lordships have seen in Article 188, through an Act of Parliament. And there are necessary implications, conferments which follow from the article.
आपका तो entire thesis ये है ना कि जी law का मतलब ये है an act of the Parliament, whether it is existing or it is subsequently made.
Yes, yes.
ठीक है? वो उस सूरत में होता जब 191 में लिखा होता the rules of the Supreme Court shall be framed by the Parliament. Yeah. What was the fun or what was the rationale of giving the power to the Supreme Court in the chapter of judicature, and at the same time turn around and say, well, you can frame the rules, you may frame the rules, but once you have framed the rules, the Parliament can override those rules.
Because it is a limited power. The reason is the structure